All right. All right. So today's docket, we're in Indiana today. One thing I should say about Indiana is not like Ohio. In Ohio, the exculpatory clauses say, pull some order in the court. So in Ohio, the exculpatory clauses, like if you sign as a parent, it applies to the kid. Not the case in Indiana. We're in Indiana today. So minors in Indiana are treated as minors. They sign contracts, they can void them. So that's an important fact that's not in any of the stuff that I put in there. So I just want to put that out there ahead of time. So that all being said, I'm springing a whole bunch of things on these students I have a video that actually gives the factual background before we get started. I'm going to play it now. It's not completely framed to either side. It just kind of gives some of the factual background, but I want you to understand it's a little bit of a crazy case. So if you guys want to turn your attention to why don't you flip the lights off for a second here? Unless you want to do something a different way, why don't we start with the video, and then we got some Saturday right there. Okay. So let's take a look at this. So I'm just gonna apologize to you guys in advance, 7 of you, because there's gonna be just a bunch of stuff that I throw at you that you weren't expecting. So it is what it is. Okay.
You know, this whole incredible tangled story, it all revolves around one thing, one machine, a single go-kart, and the young man behind the wheel, whose future looked like it was paved with gold. But that future, that golden path, it came to a sudden, brutal stop. All it took was one crash, one single catastrophic moment that didn't just break a go-kart, it completely shattered a promising career. So, that's the big question, right? Who is at fault here? Was it just a racing incident? Was there something wrong with the track? Or was it something else entirely? Well, as you're about to see, the answer is way more complicated than you'd ever guess. Because you see, when the dust settled and the lawyers got involved, the race organizers thought they had an ace up their sleeve. They pulled out a signed contract, a liability waiver that they believed made them totally untouchable. Case closed, right? Well, not so fast. So let's start at the beginning. Let's talk about our main character in all this, Ronald King, a talented young racer who was absolutely on the fast track to success. Ronald wasn't some rookie, you know. He'd been racing competitively since he was 15. He knew the risks, and he and his parents had signed plenty of these liability waivers before. So in 2018, at 17, he's ready for the big time, the Elkhart King of the Caribbean Grand Prix. And kind of ironically, the whole thing was sponsored by Admiral Nelson's spiced rum. And this is where the trouble really starts. During the very first race of the series, Ronald gets into a nasty crash. He messes up his shoulder, but what nobody realizes is that he also gets a tiny hairline fracture in his arm. It goes completely undetected. So his doctor prescribes him some pretty strong pain medication. And that little detail is about to become a very, very big deal. Okay, so now we get to the timeline. We're talking about the handful of days leading up to that second fateful race. A period where everything that could go wrong did go wrong. I mean, just look at this. It's a perfect storm of bad luck. In between the two races, Ronald has his 18th birthday. Boom, he's a legal adult. The night before race number 2, he's at a mandatory pre-race meeting, and he's still taking those powerful painkillers. Then, the morning of, he signs this all-clear checklist before getting in the car. Each one of these steps is just another link in this chain of disaster. Let's really zoom in on that night before the race, because this is where a birthday celebration, a really, really bad practical joke, and a supposedly legally binding document all collide. So, here's how this whole thing goes down. Ronald's at the sponsor's little party tent, the Caribbean Cabana. He's on his meds, his throat's dry, so he just orders a regular Coke. But one of his friends thinks it'll be hilarious to swap it for something called a Davy Jones Locker. It's a drink designed to taste just like Coke, but it's pretty much all alcohol. Ronald has no idea. He chugs the whole thing in like 30 seconds. And that potent cocktail mixed with his medication, it was an instant recipe for disaster. What happens next is just pure chaos. And it goes viral, of course. He starts stumbling around, he grabs a prop crown off a statue of Admiral Nelson, puts it on his own head, and just starts shouting that he's the real king of the Caribbean. And yep, you guessed it, his friends caught the whole ridiculous scene on video. Now, here's the crucial misunderstanding. While all this is going on, the race organizer shows up with a liability contract. He sees Ronald acting bizarrely and he asks the bartender what's up. But the bartender didn't see the prank, so he just says the only thing Ronald had to drink was a Coke. So to the organizer, it just looks like he's being a goofy teenager. He hands him the contract. So Ronald takes the contract and he signs it. But just look at this comparison. On the left, you've got his normal clear signature. And on the right, that's what he actually wrote on the contract. It's not even his name. It's this sloppy scrawl that literally says, "The real king." This piece of paper is about to become the most important document in the entire case. And just in case there was any doubt about how impaired he was, literally moments after signing that thing, Ronald threw up all over the table and passed out cold. His friends had to physically drag him home. There was absolutely no question. He was completely incapacitated. Okay, so that's the.
All right. Most of the cases. That's most of the case. A couple additional facts to add. So we've got all the players, and this is the timeline. And I'm gonna let the prosecution and defense use these slides as a point of reference. But the one thing that we need to add to this is what happened the next day. So what happened this next day is Ronald gets into a wreck. He's still a little bit hungover from his night of drinking that he didn't know he was going to be drinking. There was a photographer. So if we go to step one, step two, the photographer was there, a position near the edge of the track. Ronald sees him late, slow reaction time, crashes his vehicle, his go-kart, and as a result, ends up with a broken face, right? So he's the ideal defendant, got the broken face. Or ideal plaintiff, sorry. Okay? So that's the sequence of events that's happening. And with all of that being said, let's flip the light switch on. Now that we've laid down the factual background, does everybody all the jury members have a notes page? Now that you guys have all had the facts, let's start with the opening statements of each side, and then we'll proceed through the case.
Your Honor, we are the law firm of Ness, Vasquez, and Runk, representing the plaintiff, Ronald King. Ronald is a young boy who loves racing. He has been racing since he was 15 years old. Racing is his passion, but it is also a very dangerous sport that requires adults and supervisors to take safety seriously. In the summer of 2018, Ronald was 17, just turning 18, as he entered the King of the Caribbean. This was a major race at high speeds, sponsored by Admiral Nelson, who was a spiced rum distributor that built the Caribbean Cabana, a bar next to the racetrack that promoted drinking to the experience. During a race, Ronald suffered severe injuries, including a hairline fracture in his arm and an injury to his shoulder, which the doctor failed to see but prescribed pain meds. Later, at the bar, Ronald ordered a Coke, but his friends who were celebrating his birthday changed the order to an alcoholic drink, which mixed with the pain meds and made Ronald extremely drunk and unable to think. Then he was asked to sign a new contract for racing, and the organizers cleared him for the race. During that race, he swerved to dodge an out-of-place photographer employed by the organizer, which led to his hairline fracture rupturing. This is not a case for simple contractual agreements, but a question as to can organizers get away with failing to protect repeatedly? People have placed their trust in them. As this trial continues, we hope you begin to see the truth behind the case and realize who is truly at fault here. Thank you.
All right, great opening statements. Let's go over to the defense for their opening statement.
Your Honor, we are the law firm of Kokenauer, Dunham, Page, and Rary, and we are here representing our clients, Admiral Nelson and the owner of the Grand Prix, Elkhart Grand Prix. This case involves a serious accident, and while we sympathize with Ronald King, the evidence will show that his injuries were not caused by any negligence from our clients. As you will hear, Ronald has been racing competitively for years. He knows the risks of this sport, and he is familiar with the exculpatory contracts required for participation. Contracts he has signed many times before, including this event. By the second race, Ronald was an adult, and he acknowledged completing the required pre-race paperwork just as he had in every prior race. You will also learn that any intoxication he experienced resulted from a prank by his friends, not by the actions of Admiral Nelson's staff. We are not here to say Ronald is to blame for being injured, but as the case proceeds, we will show why the law holds that the defendants followed proper procedures, relied on valid releases, and did not cause the harm Ronald suffered. At the end of this trial, we believe the evidence will support a finding that Admiral Nelson and the Grand Prix organizers are not liable under the clear agreements Ronald understood, accepted, and had signed many times before. Thank you.
All right, so one of the key elements in this case, it's kind of a preliminary one before we get to the negligence case. The negligence case is really simple. Does the race sponsor have a duty that they breached that caused the harm? Right? That's a simple negligence case. But before we even get to the negligence case, we have to deal with the more tricky issue of these exculpatory clause contracts. There's multiple ones, right? We have ones that he signed as a minor, and we have ones that he signed after his 18th birthday in a somewhat intoxicated state. So let's start with those. In order for an exculpatory clause contract to be enforceable, there's a three-part test or three-point test. Okay. It has to be reasonable, it has to not violate public policy, and it has to, what's the third one? They can't protect people from intentional conduct, misconduct, right? So those are the three things that a valid exculpatory contract has to have. So with that being said, let's start with this preliminary issue from your perspective as a plaintiff and from your perspective as a defendant. Is this a valid exculpatory contract? And if so, if not, why not? So start with the plaintiff.
We believe that it's valid, it's not our argument that the contract is not.
So you're conceding that this is a valid contract, that it's reasonable, it doesn't violate public policy, and okay, all right. Does the defense want to respond to that?
I agree because he signed it many times before. It was reasonable and he was aware of what he was.
Okay, all right. So I guess the issue is not about the exculpatory clause in the contract itself. Then the question is, did Ronald either ratify either the contracts he signed as a minor or the contract that he signed while intoxicated? So we'll start with the plaintiff side. Why don't you give your statement of the case? And I want to take these a little off track here for a second. I think that we have to understand what it's like when somebody signs a contract when they're drunk. So can I get a volunteer who wants to be the drunk contract signer? All right, Jimmy. All right, Jimmy, come up here. So I didn't bring any alcohol with me today. You know, you have pretty sloppy handwriting, Jim.
Yeah.
Good. Oh, perfect. All right. So here's what I'd like you to do. What are things? Okay. All right. All right. So, okay. So here's what I'd like you to do. Grab that pen over there. I want you to write in pretty sloppy new sign language. I should have asked you. Can you do cursor? Okay. Okay. So that's good because it'll be even worse. All right. So then do Ronald King and the bad cursive. Like just sign it like you normally sign. Please. Yeah. You got it. Yeah. Just try to sign the name Ronald King. Okay, now, real sloppily, right? Real king, just real king. All right, so that's completely sober. Now let's here. These are special glasses. that simulate drunkenness. Okay? And it's, I don't know what level of drunkenness it actually simulates, but it's pretty drunk. So can I make sure that we got Brandy, keep him over here for a second. I want to make sure I got a spotter. Like, I don't want all of you into the thing. So what I want you to do is wear these glasses. Okay, over here to me. I'm gonna say sit on the corner of that desk so he doesn't fall in. All right. So now you're at a level of drunkenness. Now I want you to sign over here, real king. Okay, you got it? You got it. You do good. Come on, you got it. Are you doing good? Okay, real. Okay. King, come on, you got it. All right. So those are our three signature. Does anybody else want to try before I put my glasses on? Which one? Yeah. Okay, let's have one. Okay, so you try to sign the roof. Make sure you're spotting her. So first we wear this one here. So you got real king. Now you're gonna try the drunk glasses. Hold on.
Okay.
Okay. Well, at least I drunk. She's really good. Right, that's pretty. It's bad thing to do that. Okay, one more. Okay, that's okay. Good. We'll do good. We'll do good. Make sure it's happens. All right, so we're all right. All right, that's good. Okay, so that's all I wanted to say. I didn't bring my. I always wanted to try that. Okay, so let's talk about the two ways that you can ratify a contract. Okay, so because in either intoxication or when you sign as a minor, you have the opportunity to ratify a contract once you're out of the state that you were in, right? Once you're out past the intoxication state, once you're not a minor anymore, you can ratify the contract, which means you agree to the terms and you consent to being held to the terms of the contract. Okay? And they both have to be done within a reasonable period of time once you either reach the age of majority when you're a minor or you become unintoxicated when you're intoxicated. Okay? That all being said, this is a major issue in this case. So let's start with the plaintiff side. How are you going to argue that this contract, we have a contract here that seems to be valid? Why is it not the case that this contract should exempt the race sponsor and the track itself from liability?
The contract was written while the plaintiff, Mr. King, was very clearly under intoxication, but was going around, picking off of the statue, taking his crown, signing autographs with other people. And while that was happening, a race official came in asking for the autograph of him on a contract. In the eyes of someone who was very clearly drunk, that was not have been a contract to be signed. That would have simply been another paper to be autographed by someone who was just playing along in the bar with him. And afterwards, to even more clearly show that he was drunk, leaving the passage, not from his own choices, but from the choices of others around him, and not stopped by the bar and of itself, he threw up and then passed out completely immediately after signing this contract. We argue that the contract is completely voidable and thus disaffirmed afterwards by the actions of Mr. King, the plaintiff, by suing the companies themselves.
Okay, so that's in respect to the signature that they secured on a contract while he was intoxicated. What about the ones that he signed multiple ones of these before, including the one he signed for the first race when he was a minor? Why is that not being ratified?
The one he signed was as a minor, and therefore he needs to show, once he becomes an adult, the intent to ratify it, which he was not able to show because he was under pain medications and in the hospital before, so he was not able to show that physically. And then he was severely intoxicated during the chance to show it and ratify it afterwards, so he was not able to show the commitment to ratify the contract in and of itself. He did sign an acknowledgement the day after he was intoxicated, but that was just in and of itself a list and acknowledged, not an enforceable contract.
So yeah, we haven't talked about that yet. So what is this thing that you're talking about? Like explain what it is that he signed
Yeah.
after he's 18 and no longer intoxicated.
He signed an acknowledgement, signed all the contracts, and he had done everything he should have done before grace, but he signed that while severely hungover, and he did not have any clue that he signed the contract in while being severely intoxicated. It's a list, not an enforceable contract.
Okay, all right, so why don't, now let's flip it over to the defense side. You've heard everything the plaintiff has to say. What is your argument about these two different contracts, one signed as a minor, one signed while intoxicated? Why should they be considered ratified? What perspective?
We could not have assumed that he was drinking. We asked the bartender if he was drinking, and they said no. We could have. The organizer thought that he was joking, being playful for his birthday because he is celebrating his 18th birthday. He could just be putting on a show for his friends or just doing XYZ just to get attention. So we didn't really. They didn't really think that he was drunk, considering that the alcohol at the party wasn't given to him by the bartender. And the paper on the day of the race, we gave that to him just so that he acknowledged that he signed all the papers before. It was just making sure that he fully knew that he signed all those papers. They were probably presented to him at the time, like, hey, are all these papers good?
So what was, well, what is the list? You talking about he signed papers. What was he signing?
He was signing that he acknowledged that he signed everything beforehand and that he would race the race.
Okay, so it's a pre-race checklist of sorts, right? So it's, did you check your safety equipment? Did you sign the exculpatory agreement? Did you so it's a list of things that includes that as an element, right? And so from your perspective, the ratification. So how would you argue that it's being ratified? I mean, because it could be either one, right? It could be the one he signs as a minor or the one he signs while intoxicated. How is he showing that he's ratifying those previously signed contracts?
Because he is sober at the time, and I mean, he signed it knowing fully because he's been through the procedure before, because he's been in these races. He knows what he's signing. He knows what's on the list, what's not on the list. He's been there before. He knows what he's doing.
Okay. All right. Okay. So we're going to proceed with the case as a point of argumentation, as if the exculpatory clause isn't going to hold. So we need to argue the basic negligence case, because the jury needs to have all of that information in there. How would you argue that the basic deal with the negligence case? I don't think I have it up here. This is just a duty breach causes harm. Okay. So from the plaintiff perspective, how would you argue that there was a duty? So let's go back to the trial, the anatomy of the crash, right? So now we're just dealing with the crash as it is. Argue through a basic negligence case. Is there a duty that the race sponsors had that was breached, and how did that breach cause the harm in this particular case? Plaintiff team?
The duty in and of itself, if not even to keep the driver safe, it is to at least keep the track clear. And they have their own employee photographer standing in the way of the racers, which completely breached that duty in and of itself.
So reference it. Let's look it up here. Like explain it to the jury. Like what exactly happened and why is it a breach of duty?
So Ronald King was going through the turn while still suffering from a bad hangover, which I don't know if you've ever had a bad migraine. It's similar to that. It's massive headache. You're not able to do things that well. You are very impaired, as it says. His reactions are impaired. There was an employed photographer standing either on the track or very close to the track in his way, which he could not see until like halfway through the turn, in which he reacted to extremely late. And after he reacted, he overcorrected himself and crashed into the end of the track, which for a go-kart track, there's like tires and things to stop, which broke his face and ruptured his hairline fraction.
Okay. All right. So you've got the harm, you got the fracture, you've got the duty, the breach. Were they the cause for the harm? Or
There's a completely the cost.
because why?
Because if they were not there, he would have just continued driving around the turn, and it was only after he had reacted late to their presence and overcorrected himself that he actually was suffering from the crash.
Okay. All right. How would you like to the defense side, assuming that the exculpatory clauses are not valid for just for the sake of argument? Okay, I'm not saying that that's the case, but if they're not considered valid, why is it that they did not breach their duty of care? And why did they not cause the harm given this set of facts right here?
The photographer was placed in a position that he would have known because he's been in these races before. He wasn't placed in any other area. It was a designated place approved by media zones and used in many races. So considering he is a seasoned driver who should know where the photographers are, and him being not sober is not us being negligent. It's him being negligent, knowing that he is not fully capable to drive, getting behind the steering wheel. And that's just not falling on our fault. And him losing control because he had the fracture in his arm doesn't fall on us because he knew that he had the fracture in his arm and he wasn't fully capable of driving. Then, and him being 18 considers like he should know that.
Okay.
I also want to add one thing. The racers are responsible for reporting their limitations, and that is why they didn't do more through a medical check, because racers are supposed to be able to tell them, hey, I have a fracture, hey, I have this going on, I shouldn't race. But he willingly came out to race.
Right. So he put himself in a position to race even though he was injured.
And his friends could have stopped him, knowing that they caused that.
Right. So in his awareness of his injury would be because of the fact that he's taking medication to deal with an injury. So he knows he's injured. He may not know the extent of his injury, but he knows he's injured. Okay. Great. And to the plaintiff side, how do you want to respond to anything that you heard there?
No one had any idea that he had a fracture in his arm. It's very clearly states in the facts of the trial. They knew that he was injured somehow, but no one actually knew that he had a fracture in his arm. That was a much greater injury that they had no idea that got increased because of the crash. So the pain medications that they would give was for the injury in his shoulder and for a pain in his arm. They never figured out what he had in his arm, and he himself did not know.
Okay. All right. So
That's all.
Okay. Any final thoughts on the injury itself that occurred on the race day? Any final?
I feel like him knowing his own body he would know if there was a problem, or his reaction time would be delayed by an injury in his arm, which is controlling his steering wheel, that he has driven multiple times before. He's been there, he should know what his limitations are.
Okay. All right. Now, getting back to just one last time for the exculpatory clause before we get to the final statements. Why should the exculpatory clause be considered ratified first from the plaintiff side and then from the defendant side, and then we'll do final statements?
The one where he was a minor was made less so while he was a minor, so it needs to show him being ratified. The second clause, he didn't even sign his own name, but he signed it while he was very clearly incapacitated in every way, shape, and form. And then the morning after, he signed an acknowledgement list, not a contract. The day after, he drank alcohol for the first time, in which he had a massive hangover that he didn't even realize what was going on because he didn't even know he had drank out. So based on all of his actions and based on all the things around that, he had no way of knowing or controlling himself to be able to ratify each of these clauses.
Okay. All right. And then for the defense, any final statements on why should it be considered to be ratified? These two contracts that you have, one signed while intoxicated and one signed as a minor.
Well, he signed it when he was intoxicated, and so he signed it with us not knowing that he was intoxicated, and he could have been playing games. We didn't know, but he signed the first one, and then we have a second one just covering anything and everything else. So he signed the first one, but even if he wasn't fully there for the first one, he signed the second one, acknowledging that he did sign everything for it.
So the checklist is what? So
Yeah.
when you sign the checklist.
He signed
Okay.
And his friends knew too. His friends and whoever was around in that party knew what was going on with the drink, and they decided not to do anything about it. So it ultimately wouldn't be our fault.
It said some.
Yeah, and just to clarify, the friends are over the age, like they did not get served by uh the cabana people as an illegal action. Okay, so his friends are over 21, but they're not really that great of friends if they do that kind of stuff to you. But okay, so then with that all being said, then let's do final your final arguments, and then we'll send it to the jury.
When Ronald King showed up to race in the King Caribbean Grand Prix, he believed, as any racer would, that the organizers and the event sponsors would take reasonable steps to keep him safe. He believed that the track would be properly monitored, that the people running the race would ensure competitors were fit to drive, and that a company making money off this event would take responsibility for the environment it created. Instead, the defendants asked you to believe that a series of papers signed when Ronald was a child, and one signed when he was heavily intoxicated to the point of collapse, erase every bit of responsibility they owe. They are wrong, and today you have the power to say so. Ronald King is not asking for anything extraordinary, just accountability. Accountability from a raw distributor that fostered recklessness, and from race organizers who looked the other way when safety demanded action. Ronald has suffered significant lasting injuries. His face was broken, his body was broken, but the defendants want to say you signed away your rights at 17 and while intoxicated at 18. The law does not allow that. Justice does not allow that, and you should also not allow that. On behalf of Ronald King, a young man who trusted the adults and organizations responsible for his safety, I ask you to return a verdict in his favor. Thank you.
Okay, very well done. All right, and so closing statement for the defense.
Your Honor, throughout this trial, we have shown a consistent and compelling picture. The injuries Ronald King suffered were tragic, but they were not a result of any negligence or misconduct by Admiral Nelson or the Elkhart Grand Prix organizers. Ronald has been a competitive racer for years. He knows the risks of the sport. He understands the rules, and he has signed the same exculpatory agreements many times. By the second race, he was an adult. He voluntarily signed the waiver, even if jokingly, and he confirmed it again the next morning on the race day checklist. That is ratification. These releases are clear, comprehensive, and legally binding. They exist precisely because racing carries dangers no organizer can remove. We also showed that any intoxication Ronald experienced came entirely from a prank by his own friends, not anything from what our clients did. He ordered a Coke, and that is what he was served. The staff had no knowledge the drink was switched, and no reason to believe Ronald was impaired. On the track, the organizers followed standard, widely accepted procedures. Photographers are always present, and their placement in designated media areas was appropriate and expected by any experienced racer. Nothing about the track setup created unusual risk. What truly caused the crash were factors personal to Ronald: his hangover created by his friends, his pre-existing hairline fracture, and his own decision to race despite both of these. These are not conditions created by the defendants, and the law does not hold organizers responsible for risks the racer knowingly accepts or brings with it. Your Honor, the evidence shows that Admiral Nelson and the Grand Prix organizers acted reasonably, responsibly, and within racing standards. The signed waiver, Ronald's experience, his ratification, and the actual cause of the accident all point to one conclusion: the defendants are not liable for Ronald's injuries. We respectfully ask that you enter judgment in favor of the defendants. Thank you.
All right. Very, very well done for the very complicated case. So now we're going to take it to the jury. You guys have jury notes are actually the things you've been filling out. So you guys need to decide together as a team the major questions. So I'll give each jury a team page to fill out. So we're going to bring in the three juries. It'll be two juries of 5 and a jury of 6. Well, the 6 needs to be 4-2. The 5 needs to be 3-2. You need to decide the major actions. Did you ratify the contract you signed as a minor? Did you ratify the contract you signed while intoxicated? Was the language of the exculpatory agreement reasonable, and did it not violate public policy, etc.? And then finally, you're going to have to say who wins this case, right? Because then look at the negligence case, duty breach causes harm. If the exculpatory agreement doesn't apply, then who finally wins this case? Okay, so here's how we're going to do. We'll do 1, 2, 3. 1, 2, to your 2, 3. 1, 2, 3. 1, 2, 3. 1, 2, 3. 1. Okay, so let me give you guys So we'll do jury one, you go back in that corner. Jury two, you go to the breakout room, jury three back in, did I say that one already? The other corner. So jury one, jury three, jury two. And that's it. Thank you guys, and thank you both to the attorney teams. You guys did a fantastic job.
Yes, I said it.